31st, 2021. The committee is meeting on its study of corporate offshore licenses. Today's meeting is taking place in a hybrid format pursuant to the House Order of January 25th, 2021, and therefore members can attend in person in the room and remotely using the Zoom application. The proceedings are made available via the House of Commons website, and the webcast will show only the person speaking rather than the entirety of the committee. To ensure an orderly meeting, I would like to outline a few rules to follow. Members and witnesses may speak in the official language of their choice. Interpretation services are available for this meeting. You have the choice at the bottom of your screen of either Floor, English, or French. You will also notice the platform's raise hand feature on the main toolbar should you wish to speak or alert the chair. Before speaking, please click on the microphone to unmute yourself. When you are not speaking, your mic should be on mute. I would now like to welcome our witnesses for today for the first panel. Today we have from the Department of Fisheries and Oceans, Adam Burns, Director General, Fisheries Resource Management, Heather McCready, Director General, Conservation and Protection, and David Worley, Director, National Licensing Operations. Before we go to the opening remarks by Mr. Burns, I would like to welcome, of course, Mr. D'Entremont from West Nova, back to our committee again, and of course, Mr. Kent, a member for Thornhill. Good to see you here today, sir. So, Mr. Burns, when you're ready, you can start for 5 minutes or less, please.
Thank you, Chair, and good afternoon to members of the committee. My name is Adam Burns, Director General of Fisheries Resource Management at the Fisheries and Oceans Canada, and as you noted, I'm joined by Heather McCready, the Director General of Conservation and Protection, as well as David Worley, who's the Director of Licensing Operations. We're here today in support of the committee's study of offshore fisheries, including the processes related to licensing and quota transfers. We appreciate the opportunity to be here. I would like to briefly touch on some of the issues that may be related to this study and hope that we will be able to provide better and further details for you over the course of today's discussion. The offshore fishery in Eastern Canada comprises those vessels greater than 100 feet in length. There are presently 97 offshore licenses in Eastern Canada and the Arctic, which account for about 37% of total landings in the area. Sur la côte est, le ministère reste déterminé.
On the East Coast, the Department remains committed to Canadian ownership and to the review of fishing company purchases to ensure the ownership requirements of being at least 51% Canadian owned to be eligible to receive the fishing licenses is met. Under the Commercial Fisheries Licensing Policy for Eastern Canada, if foreign interests acquire over 49% of the common shares of a Canadian-owned corporation which holds fishing licenses, the licenses will not be reissued to that corporation upon the expiry of those licenses.
There is a change in the controlling interest of a corporation that holds a fishing license. DFO must be advised of the change within 15 days afterward. The ownership review requires that the license holder and all parent companies that hold a controlling interest in that license holder be majority owned by Canadians. The intent here is to prevent foreign interests from establishing effective control over license holders in the offshore. While on the East Coast, offshore licenses are issued to companies which can designate various vessels to fish the license. On the West Coast, a vessel-based licensing regime is used. In that case, when there is a change of vessel ownership, DFO requires a notice of change of ownership documentation from Transport Canada to indicate the vessel owner or owners on record and Canadian vessel registration. A similar 15-day time limit for this notification is set out in regulation. En ce qui concerne les transferts de permis, ces derniers ne
With respect to offshore license transfers, licenses are not, strictly speaking, transferable. That is, licenses are not generally considered as a property and so cannot be legally sold or bequeathed. However, The Minister does have discretion to reissue a fishing license held by one license holder to another harvester upon request from the license holder and agreement from the potential recipient.
Officials conduct a review for Canadian ownership of the transferring party as described. As well, the Minister takes into account any land claims obligations that could be relevant to the requested transfer. And finally, the Minister has broad discretion to consider the broader public interest in making any decisions related to a request for a license transfer. With respect to quota transfers, there are two varieties, temporary and permanent. In the case of temporary quota transfers, that is in-season transfers from one harvester to another, officials ensure that the transferring party and transferee have mutually agreed to the amount to be transferred, that all license fees have been paid to the Crown, and that the transferring party has the quota available to support the transaction. This type of transfer terminates at the end of the fishing season, at which point quotas are allocated anew in light of available catch and the fisheries sharing scheme. With respect to requests for the permanent transfer of quota attached to offshore licenses, officials conduct a review for Canadian ownership that mirrors the process for license transfers and ensures, among other things, that all fees and fines have been paid. Finally, if the proposed permanent transfer would have the result of altering the agreed to quota sharing arrangement for a given fishery, the department consults with industry on the proposed transaction. With respect to commercial versus communal commercial licenses, these two forms of license exist under different regulations, the former under the Atlantic Fisheries Regulations and the latter under the Aboriginal Communal Fishing Regulations. Technically speaking, there is no transfer from one type of license to another. Rather, a harvester would have to notify the department of a license relinquishment, and then the department would have to receive a separate request for a commercial communal license. The request to establish a new ACFLR communal license provokes a review and as enabled by Section 8 of the Fisheries General Regulations. Communal commercial licenses can only be issued to Aboriginal organizations as described in the regulation, rather than an individual or a company, as in the case of commercial licenses in Atlantic Canada and Quebec. I hope that the committee finds these brief overview comments useful, and we look forward to the committee's questions.
Thank you, Mr. Burns. We'll now, of course, start with our first round of questioning. Before I go to Mr. Arnold for 6 minutes or less, I would remind members to please identify who you want to answer the question. It'll make your time, better use of your time, so to speak. So, Mr. Arnold, for 6 minutes or less, please.
Thank you, Mr. Chair, and thank Mr. Burns for the introduction. My questions will first go to Ms. McCready. Ms. McCready, some of the testimony this committee has recently received regarding the state of offshore licenses in Canada's fisheries has been troubling, to say the least. We've heard that corporations are able to hide foreign ownership. Are you aware of this?
Thank you very much for the question, and it's a great pleasure to be here today. I joined Fisheries Notions about 6 months ago from Environment and Climate Change Canada, so this is the first time I've been able to appear at a committee, and it's a great pleasure to be here. I've certainly heard the allegations, and we discuss that sort of thing internally and determine if there's action that needs to be taken. I should be clear that the offshore policy is a policy that guides the department's decision-making about issuing licenses. When it comes to enforcement, Canadian vessels are governed by the Fisheries Act, of course, and then foreign vessels are governed by the Coastal Fisheries Protection Act. So that's where the enforcement activities concentrate their work. When it comes to
are those enforcement activities not under your purview, under your title?
Yes, they absolutely are. So those two acts are the acts that are in play that the Conservation and Protection Program enforces. The offshore policy that you're referencing in foreign ownership is a policy that guides departmental decision-making. However, providing false and misleading information to the department is an offense under the Act. So that would be an angle for enforcement on this issue if it were warranted.
So are you aware of any contraventions of Canada's laws and regulations that govern the ownership of offshore fishing licenses?
I'm not currently aware of any that have evidence to support them that would warrant pursuing the matter further.
So you're not aware of how corporations might hide foreign ownership?
I'm aware of the allegations. I'm aware of how we can look at those things to determine if there are issues. People talk about following the money, looking at corporate structure. Those are the types of things that are taken into consideration when the department is making licensing decisions.
So if DFO is supposed to uphold Canada's laws and regulations that govern ownership of offshore fishing licenses, and if foreign ownership of vessel licenses or some foreign ownership of offshore licenses uphold and abides by our laws and regulations, but then there are others that are not. If there are cases where they're contravention of the laws, what is DFO doing to stop them?
As I mentioned again, the policy you're talking about is a policy that governs departmental decision making. The offense would be to provide false and misleading information to the department. That's under the Fisheries Act. If we have cases where there's sufficient evidence to pursue a prosecution or other enforcement action, we would take that action. I'm not currently aware of any cases where we have that sort of evidence.
Okay, thank you. In the we know that DFO regulates fishing licenses in our Atlantic and Pacific coasts in two different ways or manners. In the Pacific region, does DFO have any tools in place to stop a foreign entity from buying any Canadian corporation that owns access rights to Canada's fisheries resources?
So, Mr. Arnold, I'd be happy to take that question. And you're absolutely correct that there are different policies in place on the East and West Coast. And in the case of the West Coast, the review by the department related to any license transfer is linked to that vessel registration with Transport Canada and not the particular ownership structure of the entity to which the license would be issued.
So there are differences from coast to coast, and could you clarify a little further whether that's DFO or did you say Transport Canada?
So it is, I mean, it's a DFO policy in terms of the differences on the East Coast and West Coast related to ownership structure. On the West Coast, the requirement when a transfer request is made, it relates to a change in the ownership of the vessel. And so we would need to see that change in ownership of the vessel, and that's paperwork that would need to be submitted to Transport Canada and then provided to us.
So does DFO work closely with Transport Canada on those?
So it's not really a DFO to Transport Canada discussion. It's the particular vessel owner would need to provide the documentation to DFO demonstrating that that change in registration has occurred with Transport Canada.
Okay, thank you. Are you aware of any foreign crews allowed to fish Canadian licenses?
I am not aware of, I actually do not have the answer to that, sir. I would need to, my colleague David Worley may have the answer to that. And I can seek to have an answer for you if not.
I can ask Mr. Worley that question or ask that we be provided that answer as soon as possible. We only have limited time left with the House sitting, so time is certainly important.
Yeah, I think on that question, I think probably the easiest thing to do is just to follow up with the committee.
Thank you very much. If a captain cannot find enough Canadian crew to operate a vessel under these licenses, does DFO allow the captain to employ temporary foreign workers to fill that crew?
I will have to put that in the same category in terms of the specifics. I know certainly temporary foreign workers are something that's used within the processing sector. And this particular issue is not one I'm directly aware of the answer, but actually I am now told the answer. I've just found the correct information, sir. I can tell you now that DFO's concern relates to the license holder themselves and not the crew. So if those individuals were legally entitled to work in Canada, then they could do so.
Are they not like other licenses?
Thank you, Mr. Arnold. We'll now go to Mr. Batiste for 6 minutes or less, please.
Thank you, Mr. Chair. And I'd like to start off my questions with Mr. Worley. The focus of this study is on ownership, transfer of corporate offshore license, and I'd like to lay some groundwork on the topic before we move forward. Could you describe step by step the process and level of review undertaken by your department staff before making a recommendation on whether a transfer should be authorized?
Sure, and thank you for that. If we're looking at a license transfer, and we're looking at the question of the ownership question, there are a few things. Typically, licensing officers will request a set of information, as well as information, attestation from a lawyer. That kind of information that we'd request would be things like the certificate of incorporation or the articles of incorporation showing ownership structure of a company. With respect to that attestation, there's a requirement to prove that the applicant or that the respective recipient meets the Canadian ownership rules. So the kinds of materials that you could get there would be things like individuals who've got beneficial ownership, say for greater than 10% of the shares in an organization, the individual shareholders, the individuals that have, say, significant control with respect to the prospective license holder. So that review looks at not only the narrow sense of the prospective recipient, but also the complete corporate structure. So you move through the entire structure to ensure that 51% is met. When you get to about that point, and the officer or the executive that's overseeing that is satisfied with it, then you've met the ownership responsibilities, and the transaction would go ahead, assuming all other fees are paid and fines are paid and all the other regulatory considerations are met. But that's just a kind of a quick overview of the ownership kinds of ownership review that you do.
Okay, I want to pivot to some of the concerns we've heard during the testimony, specifically that there may be foreign-backed entities that are using whatever methods to inflate, manipulate, or control prices at the wharf to the detriment of Canadian enterprise. On the other hand, my understanding is that DFO's jurisdiction in these instances largely end once the fish reach the wharf and exit the harvesting side of the equation, at which point the buying and processing is primarily under provincial jurisdiction. So my questions would be, is my understanding correct that the buying and processing side is primarily provincial jurisdiction?
That's correct. DFO's responsibility basically ends as the fish enter the chain of commerce.
Okay. And if that is correct and interference were occurring, whether or not it is, then in your opinion, where within DFO's jurisdiction can the department intercede on behalf of Canadians, or is this primarily a question of provincial governments?
If you're looking downstream in that stream of commerce, yes, certainly it falls into provincial category. I think on the upstream side of that, the ownership considerations are the things I've set out, and I think as well, I think that this committee is I think well versed with the inshore regulations and the old PIFCAF model. In that respect, there's the search for controlling agreements as they were under PIFCAF. That's a slightly different area than I think you're asking. But once you get into the processing side and the chain of commerce, that really falls to provincial jurisdiction.
Okay. Lastly, and I'll open this up to the other witnesses, do you presently believe that interference is occurring, and if so, at what frequency and at what level of severity?
I'm happy to start off with that, unless Adam, you want to field that?
Yeah, I mean, I can, it doesn't really matter. I actually was going to suggest that that's more of an enforcement question, so it may be most appropriate to pass to Heather McCready.
Thanks, Adam. So I can't comment on any ongoing cases. we don't have any concluded cases that I could speak about with you here, so it's tough for me to answer that question, be giving you any numbers. But I am aware of that there are allegations and people have beliefs that there are some problems.
Okay, Mr. Worley, did you want to chime in on that, or is it that just because there's ongoing cases that you can't tell this committee?
I think that I'd only be speculating. With respect to the ownership question, I mean, as I say, on the downstream processing side, I'm not sure. With respect to the ownership on the licensing side, I think we do that review and we set a bar that's, I think, fairly stringent for transfers and recipients to get over on that side. But I would only be guessing if I were trying to come up with the kind of figure you're looking for, and I think I'd defer to Heather McCready.
I don't think I have much time, but if at all possible, I'd love to know how you communicate that with the fishermen across the Atlantic on these situations that are causing a lot of anxiety and fear. But I know that you can't get to that right now.
Thank you, Mr. Batiste. We'll now go to Madame Gill for 6 minutes or less, please.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. I would like to thank the witnesses who are here today to answer our questions. I share a lot of the concerns that Mr. Arnold raised. In fact, these were raised at the last committee. Earlier on, you talked about the distinction to be made between regulatory policies in Eastern Canada and Quebec compared to the West Coast. Could you tell me, could you possibly describe these distinctions? All right. I'm sorry. Would you like me to start the question over, Mr. Chairman? Would you like me to start over? All right, fine. All right. I will thank the witnesses. I'm sure that they heard the question already, but I was saying that I also have some concerns, if not interests, that I shared with Mr. Arnold, the ones that he shared earlier. For example, I had some questions about the policies and regulations that are different depending on whether you're on the West Coast or on the East Coast and Quebec. And I was wondering if he could explain those differences. Perhaps they could describe them in different ways. I'm not quite sure which of our witnesses is in the best position to answer the question, but I would invite each of you to answer if possible. Thank you.
I can begin in responding to those questions, and I guess what I would say to begin is the structure of the fishery has evolved differently on the East Coast and the West Coast. On the East Coast, we have an offshore fleet and a separate inshore fleet, whereas that structure and approach has not been employed on the West Coast. And so on the East Coast, while we license individuals and or corporations and companies under our commercial licensing regime, on the West Coast, it's largely anyways a vessel-based licensing regime. And so because of that, the policy frame that backs that up is different. And so the focus of our review on the West Coast is the ownership of a vessel and the registration of that vessel with Transport Canada. The focus on the East Coast is the corporation to whom the license is issued directly. And so as a result of that evolution of two different approaches on the two coasts over time, the policy approach has also developed differently and necessarily differently in the sense that it needs to be established to support a different approach to the licensing regime.
Merci. J'aurais des questions. Monsieur Worley.
Thank you. I did have a question for Mr. Worley, who talked about the licenses, and he talked about the number of offshore fishing licenses in Eastern Canada, and I believe you said there were 97 licenses. Is that correct, Mr. Worley?
in comments, yes.
Oui, exactement.
There are
Donc, c'était
97 licenses.
97 permis.
Yes, so there were 97 licenses. And afterwards, and I think Mr. Burns also said this, in the initial notes when you were talking about the renewal of the license, if there are foreign interests, then there won't be any renewal when it comes to the expiry of the license. I wanted to check that because either the answer was unknown or you are lacking information to provide the answer. I would like to know what percentage of licenses that were in that situation where there was more than 49% foreign ownership. In other words, they were foreign assets and these licenses would not be renewed. If you have the answer, great. And if you don't, how are you going to get the information?
So, Mr. Chair, I can attempt to respond to that question. Of the 97 offshore licenses, what I was referring to is if there is a change in their corporate structure, I can tell you that of all 97 at this moment in time meet the Canadian ownership requirements to our knowledge. If there is a change in their ownership structure, the requirement is that they notify the department within 15 days. And if they did not meet the 51% Canadian ownership requirement, a license would not be renewed for that company.
En fait, j'avais une question relativement à ça parce que en même.
I had a question about that because on the one hand, you would say, okay, yes, they meet the requirements, but based on the questions that are answered, questions that are asked, there was room for uncertainty. So on the one hand, we're hearing talk of this, but I've also heard that there is a way to bypass the rules. They can bypass everything that has to be submitted to show actually that they are Canadian owned. So I was wondering whether you have any doubt about these 97 license holders and whether you think that some of them don't meet the current requirements.
We don't have such a concern. Certainly these requirements are in place. These are largely established companies who very much by and large behave responsibly. That being said, we do have our enforcement operations that do provide that additional assurance to us. And we know that if there were issues that warranted further action on their part, as Heather McCready noted, they would. But in terms of our view related to the Canadian ownership of those 97 offshore licenses, our view is that they do all currently meet the Canadian ownership requirements, which is 51%.
Thank you, Madam Gill. We'll now go to Mr. Johns for 6 minutes or less, please.
Thank you for your testimony. Can you tell me, does the department take a look at each species, each fishery, for example, and look at what the maximum community benefit is, and if there's leakages that are, going to foreign entities or ways to improve and plug the gaps?
So when it comes to the offshore fishing, I'm not sure if you were specifically referring to offshore licenses.
Sure, both the offshore and the processing.
So in terms of processing with the provincial jurisdiction there, I wouldn't be able to speak to any sort of analysis that provincial governments may do related to processing rules and regulations within their jurisdiction. But in terms of the offshore licensing regime, offshore licenses are just that. They're operating offshore. And so their link is different than for inshore licenses in terms of the policies that we look at. And so the primary focus on our offshore licenses in terms of that sort of economic review is linked to that Canadian ownership and ensuring that they are majority Canadian owned and meeting the 51% requirement.
Right, but there's no coordinated effort with the province. Is that what you're saying in terms of an overall strategy? I mean, we heard testimony here about Royal Greenland and about them profiting $52 million. That they bought the second and the fourth, highest processors on the East Coast, and I would assume that that's a pretty big economic leakage. And in terms of beneficial agreements, there's ways to navigate through to impact the harvesters. So what is the government doing about it? And is there other countries that have taken action to kind of reduce the foreign ownership and the leakage that's happening right now on both coasts?
So again, in terms of fishing licenses and fishing operations, they are all majority Canadian owned. In terms of processing and the ownership of processing, that is provincial jurisdiction. The department does, though, of course, work with provincial governments recognizing their jurisdiction, but through the Canadian Council of Fisheries and Aquaculture Ministers, we do work closely with provincial governments on a variety of issues. I would note that different provinces have different regimes.
I guess other countries must have different regimes, because I can't think of another country that would allow this type of foreign ownership and leakage that's happening with their fisheries. Are you looking at what other countries are doing and working with the provinces so that you can end this leakage and actually ensure that money's staying in our communities instead of leaving to foreign corporate entities? Because that's what's happening.
So certainly in terms of the fishing licenses and that aspect of things, we are confident that they are Canadian owned and that they are majority Canadian owned in all cases. In terms of the processing sector and the ownership of those corporations and those operations, the rules are different from province to province, and
sure. But you agree that they're interconnected. I mean, they're interconnected.
Well, it is true that the processing sector is okay.
Just flagging that, because I think that the department needs to take some leadership to work with the provinces so that we can plug those economic leakages. Now, you talked about both coasts, and it's been raised here multiple times. It's like we live in two different countries. Why isn't the government following through with the commitments? Well, not the commitments, but certainly the study that was presented to the minister from 2019, 2 years ago last month, around obviously dealing with foreign ownership and transfers on the West Coast, and in terms of a public registry for West Coast fishers. I think that Canadians would expect that they should be able to know who owns the quota.
Certainly, the department is working on those issues on the West Coast. I don't have specific responses or further answers to give you in terms of what possible future policy responses might be considered at this point, but certainly the department is obviously aware of the committee's report and is assessing that, and
we've heard this though, like we keep hearing this for 2 years now. This committee has heard that the government's reviewing and looking at it. In the meantime, fishers are getting squeezed. We saw what happened to a lot of fishers, what's happening to a lot of fishers. Some of them are paying 90% of their catch, to slipper skippers. And that's just unacceptable. That money's like leaving their hands. We've got 7 super trawlers right now on the West Coast catching about 100,000 pounds a day. These vessels are heading, gutting, freezing on board. They're in BC, that temporary foreign workers are being, they're trying to get them onto the boats. So basically we're going to have foreign fishing fleets if we continue down this path. And they're technically not called processors, but they're basically doing a bunch of the processing and they're shipping to Asia for the rest of it. We're losing tens of millions of dollars. What are you doing to stop that? What are you going to do to ensure that the people on board those boats are Canadians and that we're actually processing with Canadians on board?
So I will say, Chair, that this isn't an area that I direct linkage in terms of the work. It's being led from our policy and regional offices. So unfortunately, I don't have specific...
Is the department raising concerns with immigration and in terms of the concerns around this?
Again, unfortunately, I don't have specific responses. I came prepared on the offshore study, and I do apologize for that.
Okay, well, in terms of the Investment Canada Act, we saw the Royal Greenland in terms of how they're circumnavigating. They're buying up, smaller companies, and they're adding to it. What is the department doing in terms of communicating with the other departments about ensuring that the processing side, because we know that there's lots of opportunities for the government, for those controlling agreements to impact those fishers out on the water. I understand you're saying it's provincial, but there is a federal role. and there has to be some sort of communication between the departments.
Thank you, Mr. Johns. If there is an answer to that, I would ask the witnesses to probably submit it in writing over the next day or so. But your time has gone way over. We'll now go to Mr. Mazier for 5 minutes or less, please.
Thank you, Chair, and thank you to witnesses for coming out this afternoon. Mr. Burns, we've heard a lot of concern from the witnesses at the last committee meeting on foreign ownership of Canadian fisheries. What protection does the department offer to limit foreign takeovers of Canadian fisheries?
So in terms of companies to whom offshore licenses are issued, there is the 51% Canadian ownership requirement and the rules around notifying the department when there's a change in that corporate structure. And so if a company is not able to meet that Canadian ownership requirement, then they would be ineligible to receive a license. And so at the point, and licenses are issued annually, so at the point of the renewal, I'll use my quotation marks. Our lawyers don't like it when I talk about renewal. The reissuance of the license, that is a moment where that license would not be reissued if the company were not to be that 51% Canadian owned.
Okay, very good. The Canadian Independent Fish Harvesters Federation told this committee, and I quote, "Access to the fishery by these vertically integrated and foreign multinationals threatens our coastal communities whose livelihoods depend on the economic vibrancy of the fishery. What safeguards are in place to ensure that Canadians and coastal communities are the beneficiaries of the Canadian fisheries?"
Well, certainly, in terms of the offshore licensing regime, I would go back to that 51% Canadian ownership requirement. That is a key piece there. I think perhaps, and not to speak for the federation, but they may also have been speaking about inshore licenses, and certainly in that instance, we have the inshore regulations, which ensure that fishing licenses must be issued to individuals who maintain the rights and privileges of the control of that license. And with that, we have residency requirements that would then require them to be a resident of Atlantic Canada or Quebec in order to be eligible to hold that license.
Okay. Does the DFO consider economic impacts on coastal communities in its regulatory approval of corporate offshore licenses and quota transfer transactions?
So the nature of offshore licenses is that the operations often occur throughout Atlantic Canada and Quebec. And so that's why our focus is on the Canadian ownership status of the company to whom that license is issued, as opposed to the specific community, unlike inshore licenses, which do have residency requirements because they are more directly linked to a specific community.
Okay, and that's basically, it's around the ownership. Is there any other factors for consideration on that?
Well, I can, the inshore fishery is 100% Canadian owned because of those requirements that I described in the inshore regulations. And the offshore sector, each of those licenses is issued to a company that is at least 51% Canadian owned. And I should note that requirement and that corporate structure isn't just related to the entity to whom the license is being issued, but it's throughout the entire corporate structure. So all the way to the top, if you will, and all elements of that corporate structure need to meet that 51% Canadian ownership requirement.
So how do you prove that 51%? Like, who does all that work? Is that DFO? Like, explain that process a little bit to me.
Well, so the ownership of these companies is a matter of public record. So that would be the means by which, and the requirement around that 15-day notification if that structure is changed.
So when the report is done, though, like, how do you prove it? At 51, it's because it's in the public, like, or does DFO sign off at the end of the day to say, yeah, that's 51? Like, they look at the public record. Does everybody prove that this is actually factual at the end of the day?
So we would look at the public registry information related to the ownership of the company, and obviously there's legal requirements, obviously, around the truthfulness of those reportings.
Okay, and does DFO monitor economic benefits for flowing to coastal communities from offshore commercial fishing activities? And if so, how?
Certainly, socioeconomic considerations do play into the minister's decision making. It's prescribed right in the Fisheries Act legislation that that's a legitimate consideration for the minister. And so we have economic analysts who work on those sorts of things. And so, when the minister is taking any type of decision, she would certainly seek an analysis of the impacts, amongst other things, of the analysis of impacts on coastal communities.
Is that information shared with the communities?
Thank you, Mr. Mazier. We'll
Thank
now
you,
go to Mr. Morrissey for 5 minutes or less, please.
Thank you, Chair. And there may be an issue with my internet connection. If it does, you can just move to somebody else. My first question, Mr. Burns, one of the issues that caused a lot of concern within the East Coast inshore fishery was the recent sale of Clearwater. So could you advise this committee, is there any way that Clearwater Corporation, as is currently structured, can acquire any inshore fishing license that are now issued under the owner-operator policy?
So your question is if they could acquire new inshore licenses. So the answer would be any inshore licenses subject to the inshore regulations that are currently in the hands of an independent core harvester could not be reissued to Clearwater or to any other corporate entity. That's correct.
Okay, so that's clear for the record. Then Clearwater, any corporation that is licensed to fish in the offshore would not be able to acquire inshore licenses that are governed under the owner-operator regulation and policy.
Correct.
Is that correct? My next question.
Sorry, that would be under the inshore regulation. So it would be a regulatory requirement that would prescribe the eligibility.
Another question of concern from the inshore fleet was, can these offshore licenses be changed to any other categories? Could they be broken down and reissued as inshore? For instance, we take the offshore lobster. Could those licenses be changed from offshore to inshore lobster licenses?
So I don't believe so in a technical sense. No. First of all, we have our fleet separation policies. Secondly, the location of the fishery is such that an inshore vessel would not be able, I don't think, to safely navigate and undertake fishing in those offshore areas.
Mr. Burns, that was not my question. My question was access to offshore lobsters through licenses or quota. Could those licenses that are held corporately, could their status be changed into inshore lobster fishing licenses?
So the answer is generally no. I think, and that would partly be because those offshore licenses are specifically attributed to the offshore fishing area, which would be reasonably inaccessible to 65-foot or less vessels. But
I'm not talking about the vessel. Don't use the vessel. I'm strictly speaking to access to the species and the resource. And it's obviously, if you came inshore, you would use a different vessel. And we all know inshore fleet cannot fish in the offshore. That's why they're offshore. But my question was access to these lucrative offshore licenses, primarily lobster. My question is, could any corporation that has actual access to offshore lobster fishing rights through quotas or licenses, could they convert those licenses into inshore licenses and then pursue an inshore lobster fishery under the same terms as those currently licensed? Sorry, I cannot hear you, Mr. Burns.
Sorry, it's a good thing Zoom reminds me when I forget to go off mute. No, because those licenses only afford access to that offshore area.
Okay, and that's important. Could you clarify as well, in an earlier question, I believe it was you that made, you alluded to when a license is transferred from one corporate identity to another, there's still some due diligence by the department done in that stage where it's transferred. But then at a certain stage, you said you could not interfere again until the license is permanently transferred, or there's a time. So when a license is transferred to corporation, is there a timeline on it, or what may trigger a review of that license?
So what I was referring to there is if we were to be notified by a corporate license holder that their corporate structure had changed and that they were no longer 51% Canadian, they would become ineligible to have a license reissued to them. And so at the time their current license expired and a new one would need to be reissued, they wouldn't be eligible to receive it. And so it wouldn't be issued to them.
So I believe it was you that used the term permanent license transfer. What do you define as permanent? Permanent to me seems like a long, long time. It's permanently.
So I think in my opening remarks, I was referring to a permanent quota transfer as opposed to a permanent license transfer.
Okay, well then
all license transfers are permanent. Yeah.
Go to a permanent quota transfer. What do you mean? So what's permanent? Define permanent. Sounds like a heck of a long time.
And it's probably a poor use of words.
Could you clarify then your poor use of words?
Sure. So it's the difference would be a temporary quota transfer would be for one season only. The permanent would be effectively permanently moving some of that quota from one license to another. So each year that it's reissued. So if I have 100 tons of something and somebody else has 100 tons, in certain fisheries, the rules would permit me to transfer a portion of my quota, let's say 10 tons, to that other license holder, either temporarily for this year only or permanently, so that going forward, I would have 90 tons and that other license holder would have 110.
Thank you, Mr. Morrissey. We'll now go to Madam Gill for 2.5 minutes or less, please.
Merci, Monsieur.
Thank you, Mr. Chairman. I have a question that refers to what happened at the last committee session. The witnesses, all right. Sorry, Mr. Chairman, I was scared of losing my microphone once again. All right. So there were problems applying the policies and regulations due to lack of resources. It was difficult for the department to carry out its work. In your view, is that still the case? Because first, people were saying it's not possible to bypass the rules, and everything was being overseen. But then, on the other hand, people are saying it's difficult to provide any surveillance. It seems that we kept our eyes closed for 40 years, and I would like to have your view on that, Mr. Burns, as to whether we actually turned a blind eye to all of this. Thank you.
Thanks for the question. In terms of prior to the coming into force of the inshore regulations, we were working with a policy which is a different beast to implement. We now have the inshore regulations, which is I think what folks were referring to when they were referencing resources. And the difference that we now have is, and this isn't related to the offshore, but the difference that we now have is that those inshore regulations prescribe license eligibility and related to being an independent inshore harvester and maintaining the rights and privileges of that license with themselves. And so that's an eligibility requirement in order to have a license issued to you. And if you are not compliant with those eligibility requirements, a license cannot be issued to you. In the prior circumstance with PIFCAF, that wasn't the case. It wasn't a regulatory eligibility requirement, but rather a policy. And so the timelines were much more protracted. And it is true that some harvesters would be under review, which is what it was called under PIFCAF, for an extended period of time. Under the inshore regulations, if there is a question around eligibility, and around the separation of those rights and privileges from the license holder, then that license holder would need to demonstrate their compliance with the regulations before a license could be reissued to them. And so at the moment their license expires, their ability to fish would cease until they rectified that and a new license were issued.
Thank you, Madam Gill. We'll now go to Mr. Johns for 2.5 minutes, please.
Yeah, thank you, Mr. Chair. And now a couple of things. I mean, Madam Gill, I think summed it up about turning a blind eye. I mean, my concern is that here we hear the department 2 years ago, we get this report about stopping the transfer of foreign licenses on the West Coast. No action so far. A public database so we can even know who owns the quota. I mean, I don't think this is rocket science. I think it's something that Canadians deserve to know. And do you not believe that if the government doesn't take action on these really important, clear steps that this committee was united behind, that you know, we're gonna, if government doesn't have a backbone, we're gonna lose all our corporate and foreign, you know, lose all our fisheries to corporate and foreign interests. Do you not agree?
So Chair, unfortunately, I don't have much of a response. I do apologize, Mr. Johns.
Okay, we haven't seen any action. I'm just reinforcing it that, you know, you're here, you haven't got any answers. It's been 2 years. We're looking at U.S.-based Pacific Group, for example, on the West Coast. They bought up the processing. Our fishers are getting half of the amount per pound to fishers in Oregon and Washington, just to give an example. And I mean, I think that the department really needs to do a socioeconomic analysis of each fishery and plug these economic leakages. And you haven't brought any sort of idea that the government's looking at that they're working in conjunction with the provinces. What is the department recommending to the minister? Is this something that you're looking at?
Sorry, just
and I'm saying both coasts, because like we're seeing the leakage on the East Coast in the processing. So just to clarify.
So with respect to the processing sector on the East Coast, you know, certainly discussions around a variety of things that relate to the management of the fishery occurs at the Canadian Council of Fisheries and Aquaculture Ministers in collaboration with their provincial counterparts. It is their jurisdiction. It's outside of DFO's jurisdiction to intervene in the ownership structure of processing companies.
So the DFO is saying that it's not their problem, that it's economic leakages could be happening. Harvesters are basically getting robbed blind on both coasts, and it's not the department's issue, that it's not their issue. Is that what you're saying?
It's not within our jurisdiction to intervene within provincial jurisdiction. We don't have the tools. They exist in provincial jurisdiction to regulate the processing sector.
It sounds like a big breakdown.
Thank you, Mr. Johns. And not to pick up for Mr. Burns, but processing on the East Coast is totally provincial. And if it's the same on the West, the feds don't get involved in the processing at all on the East Coast. It's done provincially. Mr. Arnold, for 5 minutes or less, please.
Thank you, Mr. Chair. Mr. Burns, I'll start with you this time around. Mr. Burns, in the Pacific region, DFO created I-class licenses to support Indigenous harvesters. How many or what percentage of those I licenses are in long-term control agreements with investors, processors, or foreign interests?
I don't have that number, but we could. I'm not sure that we could provide. I could work with my colleagues in Pacific region. I wouldn't even want to speculate if the answer would be greater than 0.
Okay, the reason I ask this is that we've been told that Indigenous harvesters have to go through processors to access most of these licenses. Is this concerning to you?
Again, I don't have specific details around this particular issue.
Do you have any information on it? If you don't, that's troubling that we would know about it as committee members, but you as senior DFO officials have no knowledge of it. That's concerning to me, and I think concerning to this entire committee.
So it would be a matter that is managed by our DFO regional colleagues in Pacific region.
Not your purview then?
That's correct. I understood that the study today was related to the offshore, so that's what we came with prepared items on. But I'm happy to get you the necessary response to your question.
Okay, thank you. I'll turn to Ms. McCready now. Many BC fishermen feel that they have no choice but to sign co-venture agreements. Recently, one such fisherman passed away, and his family thought the fishing quota identified in his will would go to family members, but the co-venture agreement actually gave it all to the processor. How do we reform these agreements involving DFO fishing licenses and quota so that there can be equity and equality for Canadian harvesters and their partners?
Thank you for the question, but I'm not sure if that's really an enforcement question. So I run the Conservation and Protection Program, which enforces the laws that the DFO puts into place. It's not my area of responsibility to be changing laws or policies. I'm not sure if any of my other colleagues have an answer or some thoughts on that.
So, Mr. Chair, I mean, I could say that, it is definitely true the policy regime on the East Coast and West Coast are different. I don't have the specifics of the case you're referring to and wouldn't want to speculate on the particulars of a particular case without looking at it in its entirety.
Okay, thank you, Mr. Burns. Could you tell us what the current level of foreign investment is in Canadian offshore fisheries? And if you have to break that down to East Coast, because you say that's what you've come prepared with, please do so.
So, in fact, there are only East Coast offshore fisheries. Such a class of license doesn't exist in the West Coast. I don't have the particular percentage of Canadian ownership of each of the 97 licenses, other than to say that in all cases, all 97 are greater than 51% Canadian owned.
Okay, thank you. In the context of the 2019 study on West Coast fisheries, the committee recommended that the federal government establish a public online database that includes information on the beneficial holder of all fishing quotas and licenses, as well as all sales and leasing of quota and license holdings. In the government's response to the report, this recommendation was not addressed, though it did note that it will begin consultations on issues raised in the report. These consultations had been delayed by COVID-19. Should a public registry be required for East Coast offshore fisheries to increase the transparency and quota license ownership and transactions?
So that would be a question for the government. I wouldn't want to speak to that in particular. What I can say is our policy around the 51% Canadian ownership is strictly enforced. And of course, the ownership structure of public companies is publicly available.
Okay, thank you, Mr. Arnold. We'll now go to Mr. Cormier for 5 minutes or less, please.
Bonjour, merci tout le monde d'être là.
Good afternoon. Thanks to everyone for coming. Mr. Burns, just to continue on what my colleagues were saying earlier regarding foreign interests that are becoming increasingly present. Yes, the fishery is going well. The quotas are high. The resources are there, especially for lobster. Yes, the catch is very good right now. What is concerning, though, is that there are more and more foreign companies that are making crazy offers to harvesters. They're offering $2 or $3 extra per pound of lobster, for example. I know full well that the provinces are responsible for the processing, but before those products get to the wharf, it is a resource that belongs to Canadians, and the federal government is responsible for it. Are you familiar with a company called Royal Greenland that is increasingly present in the region? They made some offers with regard to shrimp, for example, in Quebec, Newfoundland, if I'm not mistaken. And this year, in fact, on the wharf, they were asking $4 extra per pound for crab or lobster. I'm sure you know that the effect of this is that our fishers are going to sell to those companies, Royal Greenland, is perhaps, how should I put it, subsidized by the Danish government. I'm sure you're fully aware of what is going to happen if those companies remain in the region and offer those kind of prices. Our harvesters are going to sell to those companies, and that's where the problems are really going to start. Are you aware of those companies? There are an awful lot of other companies that are buying processing plants here in Canada. Are you aware of those investments and the presence of those companies that are subsidized by the Danish government? And what are you doing to ensure that our fishing industry remains in our coastal communities?
Chair, in terms of response to ensure that Canadian licenses remain in our coastal communities, certainly the inshore regulations and the 51% Canadian ownership requirement for offshore licenses ensure that and achieve that objective within the licenses themselves. In terms of the processing sector, as mentioned, it is outside of our jurisdiction. We don't have any jurisdictional space to regulate the processing sector itself. And so that would be outside of DFOs.
I understand that, Mr. Byrne, but like, let's take it that way. Like, before it's taken to the processing sector, these resources belong to Canadians again. So these companies like Royal Greenland that are backed by the Denmark government are coming here on our wharf offering like higher prices than the market can, pay for it. And then we just let these resources like be processed by them, sometime in New Brunswick, sometime in Quebec, sometime elsewhere. And after a while, when they're going to take the control of all of this, is going to create some kind of monopoly, and we will lose all our industry in our region. So are you doing something right now? Are you monitoring this company or other investment that are, wanting to come to New Brunswick and doing like business like that?
So in terms of the processing sector, that's outside of DFO's jurisdiction. It's a provincial jurisdictional question.
Well, again, Mr. Byrne, I understand what you're saying, but I mean, like, company like Royal Greenland, are you aware of this company that are coming to Canada and again backed by the Denmark government and trying to have a control over our fisheries? Because you stated earlier that it's important to have the licenses stay in our community. Yes, the licenses is one thing. But if the resources is going everywhere, and not in our community, and the price are going so low than compared to now, like, what are we going to do in 10 years from now?
So the inshore regulations would prohibit inshore license holders from passing any of the rights and privileges related to their license to any processing company, including one that may be owned by Royal Greenland. And so that requirement of maintaining the rights and privileges with the license holder would prevent that license from entering into a control by a processing company. And in fact, the license holder's eligibility would end should that occur.
So basically,
thank you, Mr. Cormier.
Thank you, Mr. Byrne. Thanks for your answer. Thanks.
And I want to thank our witnesses, Mr. Burns, Ms. McCready, and Mr. Raholi, for being here today and providing much valued testimony. We're now going to suspend for a couple of minutes while we change over to our next panel of witnesses, and then we'll get to some statements and some questions. So we'll suspend for a moment. to make just a few comments for our next lot of witnesses. When you are ready to speak, click on the microphone icon to activate your mic. When you're not speaking, your mic should be on mute. And when speaking, please speak slowly and clearly. I now, of course, would like to welcome our second panel of witnesses from the Maritime Fishermen's Union, Mr. Martin Mallet, Executive Director, from Regroupement des Pêcheurs Professionnels des Sud de la Gaspé. We have Claire Canet, Project Officer, and from the United Fisheries Conservation Alliance, Colin Sproul, President. We will now hear opening remarks from Mr. Mallet for 5 minutes or less, please.
Merci, Mr. Chair. Good afternoon, and thank you on behalf of the Maritime Fishermen's Union for giving us the opportunity to speak today. Our organization represents over 1,300 independent inshore owner-operator fishermen in New Brunswick and Nova Scotia. We are grateful for that all parties supported changes to the Fisheries Act protecting owner-operator and the fleet separation in legislation, with the purpose of keeping Atlantic Canada public resources in the hands of fishers in their communities and protecting the inshore fisheries from corporate control and influence. However, we are still very much at risk from losing our fisheries from other angles. In recent years, mom and pops, family-run and community-based fishing and processing enterprises have been on the international menu to be bought and agglomerated by large corporate interests owned by foreign national or out-of-province investors, whereas locally run enterprises would reinvest most of their business revenues within their community and province of origin. Large-scale corporations are interested in profits for shareholders, not sustainable rural communities that depend on local fisheries resources. There are more and more examples of foreign ownership takeovers of our marine resources and benefits across Canada. On the East Coast, we can cite, for example, Royal Greenland in Newfoundland and Quebec, Thai Union in New Brunswick, Clearwater in Nova Scotia with the recent involvement of the Premium Brands holding component. And as was mentioned earlier by Mr. Cormier, Champlain Investments in New Brunswick and Nova Scotia, and the list goes on. For today's presentation, I'll use the example of the Champlain Capital company based out of the US, but with an affiliate company which is Champlain Financial Corporation out of Montreal, to illustrate the concerns since 2017. Champlain has taken control of 8 processing plants in small rural communities across New Brunswick and Nova Scotia. Officially, this investment group has tried to promote the positive impact of this merger for the regions by stating the creation of more opportunities for synergies and reduction of costs, as well as development of new products. However, it is also the creation of a monopoly with the potential of creating an uneven business environment for the remaining local processing plants, potentially driving them out of business to remove competition and open the door to fix the price for fish for local fishermen. Furthermore, dividends from local businesses that would have generally remained in the communities to the benefit of other supporting businesses and community members now goes to out-of-province and international shareholders. Also, will they shut down some of the less efficient plants in order to improve profits, to further consolidate and improve bottom lines? To this question, the answer is yes. And for example, back in 2020, one of their recently bought plants in eastern New Brunswick burned down and was never rebuilt. Instead, they reinvested in their other processing facilities, thus consolidating and improving company profits at the expense of the community that lost their plant. Most of the 150 plant workers that day when the plant burned lost their jobs in a small coastal community where the fisheries sector is the main employer. So in closing, our organization supports the need in our industry for appropriate access to capital for continued maintenance and growth of the fishing and processing sectors. However, there is an urgent need for an effective set of strategies for monitoring and hedging of foreign national interests in our public marine resources. Maybe a working group of federal and provincial governments, industry, economic, financial, and legal experts could be struck to do a thorough study of the situation and develop strategy options to address the issues. Currently, and as stated in the presentation by DFO just before myself, the present DFO and provincial fisheries management structures do not have the tools necessary to address foreign ownership control issues of our Canadian fisheries resources and benefits. The second point I want to raise is the need for appropriate financial aid programs to support intergenerational transfers of owner-operator fishing licenses to new entrants, but also incentives to support processing sector businesses so that they can remain locally owned and operated. However, even the best programs here will not be able to compete with deep pockets of international corporations. And finally, in ending, our public fisheries resources must be considered as part of our Canadian national interest and food security priorities. Currently, they are being taken away from Canadians at an alarming rate. This issue has got to become a priority for our elected officials and policymakers. Thank you, and looking forward to your questions.
Thank you, Mr. Millet. We'll now go to Madame Kane for 5 minutes or less, please.
Thank you very much. Bonjour, Monsieur le Président.
Good afternoon, Mr. Chairman and members of the committee. I would like to thank you for listening to the presentation from the Gaspé Peninsula, represented by the Regroupement des Pêcheurs Professionnels du Sud de la Gaspésie. My region depends a great deal on fishing for its economic development. We represent about 600 jobs, for example, and seafood processing plants in the coastal regions of Quebec that depend on the catching industry to operate represent more than 3,500 jobs. In 2019, the commercial fishery in Quebec, including the fisheries carried out by First Nations Group, represents a total of landed value of $378 million. Lobster caught in the Gaspé represents 24% of this total value. On average, 80% of these landings in Quebec are exported and 10% remain in Canada. However, when we look at structures such as Clearwater or Royal Greenland, Quebec, the percentage of exported landings is much higher. For example, Royal Greenland, owner of the Matane processing plant, exports 95% of the landings to Europe and the United States, leaving only 5% of the fish and seafood products to feed Quebec and Canadian population. In 2019 and 2021, Royal Greenland used the techniques that were mentioned by Mr. Cormier, and it was quite alarming. It had a huge effect on the activities of our processing plants here in Canada because there were a number of purchasers who were making offers to the harvesters. The Royal Greenland Company focuses on selling abroad. Its strategy is to continue to leverage its broad species portfolio, global market reach, and customer base to generate profitable growth while expanding its sales distribution into new markets and channels. For example, the Premium Brands Network. And this is all to increase the productivity and reduce costs to generate higher margins from their vertically integrated global supply chain. So we have two examples with that company that demonstrate that foreign ownership of processing by Royal Greenland or vertical integration logic, as is the case of Clearwater Premium Brands, has an impact on the food security of Canadians because the percentages exported are clearly higher than what is exported by 100% Canadian-owned companies. Clearwater and Premium Brands do not own any inshore commercial fishing licenses, and we have heard that they cannot get such licenses. However, Clearwater is 50% held by First Nations, and they do own several inshore commercial fishing licenses. They are communal fishing licenses, and so they are excluded from the protection of the new owner-operator regulations because those commercial fishing licenses are communal licenses. The communal commercial fishing licenses were originally fishing licenses subject to the protection of the fleet separation and owner-operator policy. In a perverse effect of the exclusion of these licenses from the regulations, current and future commercial fishing licenses held by these First Nations are not protected. In the context of increased access to the fishery to achieve a moderate standard of living by First Nations, we can only see an increase in the number of communal licenses to market catches falling outside the protection of the new DFO regulations unless DFO ensures that all fishing licenses to market catches receive the same protection. It is wishful thinking to believe that these companies, which are part of a strategy of vertical integration and control of the outlets for fishing catches, don't see an opportunity in unprotected access to an increasing number of community fishing licenses and the ensuing catches. In the context of the vertical integration logic of Clearwater and Premium Brands, it is clear that without safeguards, we will see an erosion of the scope of the owner-operator and coastal fisheries protection regulations and an increasing number of commercial fishing licenses exposed to takeover by just a few. The corporatization of fisheries through vertical integration and private investment serves to ensure dividends for few individuals, families, or foreign governments as shareholders rather than prioritizing the transfer of profits to coastal communities. Before we know it,
we do have a submitted copy of your statement, and all the members will have access to that. But I want to go on now to Mr. Sproul for 5 minutes or less, please.
Good evening, Chair and honorable committee members. Thank you for the opportunity to appear tonight. The Unified Fisheries Conservation Alliance is a newly formed alliance of commercial fisheries stakeholders calling on the Government of Canada to establish clear, lasting, responsible regulatory oversight for all fisheries, commercial, food, social, and ceremonial. Established in 2020, the UFCA represents thousands of independent multi-species commercial fishermen and fishery associations from across the Maritimes. Our membership also includes small to medium-sized businesses that are directly or indirectly tied to the Atlantic Canadian commercial fishery. For thousands of Atlantic Canadians who work on boats, wharves, processing plants, and throughout the supply chain, the commercial fishery is their livelihood. For rural communities and governments, the fisheries represent jobs, a tax base, and economic impact that helps to provide vital services for all residents. Unfortunately, regulatory uncertainty is causing anxiety and concern amongst fishers and other industry stakeholders over the long-term sustainability and prosperity of the industry. Clear rules, regulations, compliance, and enforcement are needed. We want to work with the Government of Canada and First Nations to inform and understand viewpoints and ultimately establish regulatory certainty. Our members reject all forms of racism, intolerance, and violence, and believe there is a path to move beyond the controversies and heated rhetoric of recent months to a positive outcome for all. The UFCA believes that Indigenous and non-Indigenous fishermen can work side by side like they do today in the commercial fishery. We recognize and acknowledge the importance of cooperation with Indigenous communities and that Indigenous fishermen have a right to fish for commercial, food, social, and ceremonial purposes. Just as commercial fisheries operate today, there is room for diversity. There can be differences within allocation structures, administration, and process. However, rules must ultimately and clearly form part of an integrated set of regulations that conserve fishery resources for generations to come and ensure a fair and respectful fishery for all. Tonight, I would like to discuss the imminent Clearwater Seafoods deal and its risks for coastal communities. The current framework of the deal represents a tremendous missed opportunity for further integration of Indigenous fishers into Atlantic fisheries and reconciliation in our communities. It picks winners and losers amongst First Nations and further divides Indigenous and non-Indigenous fishing communities needlessly. There is a better way, and it starts with open dialogue and an end to secret deals at DFO. Communities adjacent to resources deserve a voice in decisions made in Ottawa, and when they are excluded from the conversation, they invariably lose. We have serious concerns surrounding the proposed framework for the deal, including the lack of protection from the future potential for transfer of ownership of Canada's natural resources to a foreign entity, threats to the owner-operator policy, needless concentration of fishing effort, and others. Clearwater's monopolized lobster fishing area alone is larger than all lobster fishing areas of Nova Scotia combined. The current deal would exclude all fishers but one giant factory-style ship from this huge economic potential, including a majority of Nova Scotia's First Nations and all moderate livelihood fishers. What should be of equal importance to this committee is the fact the current deal would surely pit the Mi'kmaq against the Inuit in a battle for access to valuable northern shrimp and fish quotas. This fact could be a motivator for the deal and must be explored in more detail. It would be difficult not to view Clearwater's recent outreach to include Indigenous partners as a response to the government's rightful decision to abide by the principles of adjacency to a resource and fisheries management and take a portion of the company's valuable quotas and deliver them to northern communities, both Indigenous and non-Indigenous. It is beyond belief that the current government can ignore the potential for this fishery access to aid in the integration of moderate livelihood fishers. While it may be possible for the politicians involved on all sides of this deal to consider it purely a business transaction, it is surely not viewed that way in fishing communities across Atlantic Canada. The reality is that what's best for Indigenous fishers, the actual people out on the water trying to make a living, is also the best for our members. What's best for a large corporation seldom is. It is high time for government to unite us along these lines instead of dividing us. All communities can benefit from these resources if their voices are allowed to be heard. I'm anxious to give more details on a better way forward. Honorable members, thank you. I invite your questions.
Thank you for that. You're just almost exactly on time, which I'd love to see. We'll now go to round of questioning, and we'll start off with Mr. Arnold for 6 minutes or less, please.
Thank you, Mr. Chair, and I want to thank the witnesses for their, I think, fairly honest testimony here today. Mr. Mele, thank you for your references to how this is affecting processing and consolidation and centralization and so on. And it reminds me very much of what I've seen happen in British Columbia with our sawmill and wood processing situations out there. We've had Canadian companies with U.S. interests tired of the Canadian tax regime and oppressive culture here and spend their investment dollars in the U.S. rather than reinvest in Canada. So we've lost out opportunities for Canadian workers, Canadian jobs, Canadian revenue. And could you elaborate a little more on what you've seen? You talked about the one plant. I believe it was you that talked about the one plant that did not reopen, and how many jobs were affected there because of this centralization, maybe we'll call it.
And again, I'll give you a few more examples, but I want to reiterate that I really don't have many solutions to the issues that are currently being raised today in the last few weeks by this committee. I think this is the first step, and there needs to be a thorough study done by a group of experts to come back with some more details and potential solutions. It seems to me, from my perspective in New Brunswick and Nova Scotia, that in some areas where for instance, in the case of the inshore lobster fishery, where in areas in New Brunswick, for instance, where the value of the licenses, the value of the fishing enterprises have been increasing phenomenally in the last 10 years, that there's all of a sudden over the last 5 years a lot more interest from outside of province interests and international interests to buy into the local corporate processing sector and agglomerating these plants that in some cases can be bought for a few $1 million. And so it's still early, still in the game in some areas where maybe it's not too late to try to turn back the steam. But in some areas across Nova Scotia and on the West Coast, in particular in BC, I mean, there are flagrant examples of corporate international investments, and we need solutions, right?
Thank you. And maybe I'll ask each of the three of you if you could give us a somewhat brief answer of this next question. Does it appear to you that either the department or government would rather get rid of the inshore licenses and the small processors and so on in favor of just one or large, not necessarily one, but larger organizations and corporations because it might be easier for them to manage?
If I may, it is difficult to speculate on the intention of the government or of DFO, but certainly what we have been seeing on the ground and how the fisheries have and the fishermen organization have been treated, and the lack of socio-economical studies and socio-economical competence from DFO would tend to suggest that it would be a lot easier for them to deal with only one or two big corporate and get rid of inshore fishermen. But again, it is difficult to speculate on the intention of a government or a ministry.
Thank you. Mr. Sproul?
Like Ms. Kene, I find it difficult to speculate on the intentions of the government, particularly when we're very often excluded from them. But I will tell you that that is certainly the view of my members in Atlantic Canada, and that they.
Thank you. Yeah. On that piece of it, then, one of the questions I wanted to get to, and I know time is very short. Do you feel that there's been adequate consultation and information provided to your organizations as to the transfer of licenses and in light of the Clearwater deal? Please provide a brief answer if you can.
In response to that, I would say that certainly, actually, I'm just going to pass off to Claire.
From the Quebec point of view, there has been no information and no consultation at all about it. However, this is a deal that is concerning First Nations and from other provinces and British Columbia and Nova Scotia. But I'm not aware of it. So Martin may be aware of any consultation, but I'm not aware of any.
Thank you. Mr. Mallet, I see you have your hand up.
Briefly, I'm not aware of any consultations with industry representatives. We've heard from the department and the minister's office that it was within Minister Jordan's hands presently and that they were exploring the question currently.
Okay, so it really seems like there's been very little consultation for Canadian processors to be able to provide Canadian products to Canadian consumers. If you have anything further, please provide it to the committee because I recognize the chair is going to tell me my time is up.
I would just like...
You're absolutely correct. If you could provide it in writing so as the committee could have a look at it, we'd appreciate it if we don't get a chance to hear it. We'll now go to Mr. Cormier for 6 minutes or less, please.
Merci, Monsieur le Président. Bonjour à tous les témoins.
Thank you, Mr. Chairman. Thanks to all of our witnesses for coming here. And especially to Ms. Canet, who is my neighbour just across the bay. Mr. Mallet, to get back to the situation with Clearwater. We got an explanation from senior officials of the department. I would just like to get back to this, though. What scares you about all of this transaction? Because the officials seem to say that everything was in order. Perhaps you could say a few words about the First Nations and concerns that you might have about other communities that could be at a disadvantage. Perhaps you could give us a quick summary of what you think. Yes, okay, very quickly. The nature of the agreement is quite bizarre. Nobody can explain us why the licenses have to be transferred to a secondary company or secondary entity. And I'm going to give the floor to my colleague now, Claire, who can answer. Well, indeed, there are a number of aspects that seem rather irregular to us when it comes to transferring the licenses to the First Nations. Another aspect is the vertical consolidation of some of the companies. As I explained in my testimony, a number of commercial communal licenses are held by groups that are 50% shareholders of Clearwater. So there's clearly a conflict of interest when it comes to what's going to happen to the catches. Vertical integration is going to limit access to the fishery or to the catches by Canadians. The other point is that we will end up in a monopsony situation where the more purchasers have access to the catches, the more they will be able to fix the prices at the wharf that they're going to pay to the fishers. So that's going to put them in a vulnerable position.
Mr. Sproul?
I think that there are a lot of questions around the ownership. I think one of the most important things that we should examine is a comparison of value versus cost that was paid into this. And, you know, we see by the $250 million split in a 50-50 partnership. In an inshore fishing business, we all recognize that the key asset in the fishery is the access to the fishery. And when you look at the ownership stake of Premium Seafoods owning the depreciating onshore assets and the Coalition of First Nations owning access to the fishery, we're left wondering if there's a level to the agreement that's not visible to the department. And I think that there's a due diligence on the department's behalf to find that out.
Okay, good. Thank you. Mr. Mallet, just to go back, and I know it was quoted a lot of being like the one who named like this company Royal Green Line a lot, but look, I think I'm not the only one that faced these challenges. As you know, Mr. Mallet, in this region this year, I received a lot of phone calls from fishermen and producers that, you know, they were present on the wharf offering a lot of money to fishermen for their catch. DFO official seems to said that it was maybe more a provincial issue, but at the end of the day, like I said, the resources belongs to Canadians. I think we will have a huge problem if we let that happen, like having a foreign company like Royal Green Line that is backed by Denmark government that, you know, everybody is thinking about. So what do you think the department should do about that? Because it's going to be a huge problem if we lost, like, you know, our industry that we have many years built in our community. What do you think we should do about this?
Well, for starters, I can't think of any other country that would enable in their fishery to have some corporate entities owned by other countries to come in and own processing plants and quotas. I think there should be special consideration here done to these types of international interests. I mean, as I said in my statement, I think that the fisheries resources in Canada should be considered a strategic Canadian resource and should be connected with some special rules to protect this resource for Canadians.
Okay, Mr. Sproul, I think you have your hands up. So
I think the question that begs answering is why 49% of a Canadian resource should be allowed to be owned by a foreign entity. I think that we should explore the history of how that came to be in Canada and why it can't be changed.
Mr. Mallet, did you have those concerns raised to you at your association by fishermen in the region about Royal Green Line this year and the previous year?
Yes, and I mean, we have to say that in New Brunswick it's not much of an issue at this point because they've been mostly doing
In
their
Quebec.
progression in Quebec and Newfoundland. But I mean, they have been extremely aggressive in the past 10 years, acquiring over years many quota shares and plans. And in the case of Newfoundland, our colleagues from the FFAW would be better placed to state how it's really affected their capacity up there to have a appropriate price for their fish because they've created such a monopoly.
Madame Canet, je sais que dans votre région aussi, ça a été...
Thank you, Mr. Cormier. We'll now go to Madame Gill
Thank you,
for
Mr.
6
Chair.
minutes or
Merci.
less, please.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. I would like to thank the witnesses for joining us today. I must admit that I am very concerned about this. We've spoken to senior officials, and they didn't see what kind of concerns that we could have about the situation. They didn't even seem worried about the way that people are bypassing the regulations. And the result would be more foreign ownership. So I thank you very much for your testimony today that shows the exact opposite. Yes, it is a big concern, but as Mr. Mallet said, there are some solutions, some strategies to solve this. I have some questions for all of the witnesses, but I'm first going to ask my question to Ms. Canet, who talked about the lack of knowledge about the social and economic impacts that the department seemed unaware of. I was wondering whether you could talk a little bit about the negative impacts on the coastal communities. Thank you very much for that question, Ms. Gill. At no point have we been made aware over the past few years of any socioeconomic impact carried out by DFO. Some decisions were being made with regard to the black whale, for example, or regarding the lobster fishery, or if it came to the exclusion of communal licenses for owner-operators, or when it came to vertical integration. The impact is clear. It's indirect, but it will come. It pertains to prices that are being offered to the harvesters. The fishermen have their landings, and after a week, they will find out how much they're going to be paid for their catch. When you end up in a situation where you have a monopsony, where you have Clearwater or Royal Greenland, and they come and take control of the purchases, then the fishers who are supposed to be able to act independently and get the direct benefits of their fishing license end up in a situation where they cannot get those benefits because they don't have any power to do so. At no point did DFO look at that socioeconomic aspect, which is a critical part of a fishing license. What kind of socioeconomic situation will this leave for the fishers? Thank you very much, Ms. Canet. I am very concerned about this because earlier on we talked about the potential disappearance of an economic sector in our regions to the benefit of foreign companies. I must admit that there are a number of studies being carried out by this committee, and I see very little proactive measures taken by the department. I feel the same way as you do. I don't see any forward motion on this matter. Mr. Mallet suggested a strategy. It may not be up to the senior officials of the department or the government to act. If it's not up to them, certainly we are members of this committee. We are parliamentarians. We're not necessarily on the government side, but I was wondering whether you had any suggestions as to what we could do to intervene. My question was mainly for Mele, but the others can answer as well. Well, it was clear in the previous presentations to the department that the department wasn't even in a position to look at the socioeconomic value of the fishery in our communities. They don't have the tools required to cooperate with the provinces, to cooperate to deal with the foreign interests who are starting to buy up the processing plants in our smaller communities. How to solve this? Well, we can't start today. I mean, can't do anything today, but we can at least have the discussion. We can perhaps set up a group of experts who could do a detailed study of the problems and possible solutions. As Mr. Sproul, we could work with members of the industry to make this all very transparent. Well, one of the avenues that could be explored is to give a mandate, a socio-economic mandate to DFO, and give them the power to manage that part of the fishery. Since 1993, there hasn't been any socio-economic study carried out by DFO. The fishery is still one of the largest employers of the coastal regions of Canada. And despite that, no department has the jurisdiction to study that industry as a whole, as an employer. We represent $7 billion of revenues for Canada. And the DFO doesn't have any mandate. In fact, no department has any mandate to look at the socioeconomic aspects. So perhaps if there were a department who could look at what this sector represents, that would be a huge step forward.
Mr. Johns, for 6 minutes or less, please.
Thank you. Thank you to all the witnesses for your really important testimony. And maybe I'll start with you, Mr. Mallet. You heard, Mele, you heard the previous round, I take it, from the bureaucrats at DFO. And it seems that they're just passing the buck when it comes to, you know, any sort of federal authority on the processing. They're saying, washing their hands of it, saying, hey, this is provincial. Do you think that they should be let off the hook, or do you think the federal government actually has a role to play?
Oh, absolutely. I think that the federal government has a huge role to play, especially where, I mean, these corporate international interests are, our federal jurisdiction when it comes to protecting our national interests. Where is it in the fisheries or agriculture or the whatever industry that we want to delve in? So. I think they have a responsibility to move on this. They have a responsibility to build the foundations that are needed to collaborate properly with the provinces. And the minister or the PMO's office needs to give the department the mandate, if that's the problem, that they need to do the work that's needed.
Yeah, I really appreciate that, and I think you also touched about other countries, and as I did in my earlier round with the department, and Ms. Canet as well touched on that. I mean, do you not see? Can you think of another country that sells out their fisheries like we do in Canada?
If I may, I've lived in New Zealand for 14 years. In the South Island. In 2000, it was the beginning of a process where fisheries had been, a greater access to fisheries have been granted to Maori groups, and rightly. What I have seen, however, within 10 years is that all the licenses were then held through a Maori corporation. And this corporation then was bought at 50% by Japanese. All the fish that is now fished by the biggest New Zealand Fishing Corporation goes to Japan. I could not get, living in the second biggest city in New Zealand, I could not get one fish fished here in New Zealand, and the cost of it was prohibiting.
Thank you. So that's just another example of, foreign companies preying on, countries where they've got lax rules. Mr. Malley, can you speak about the importance of the government of Canada working in collaboration with the provinces and taking a whole of economy kind of socioeconomic approach to looking at our fisheries and identifying any leakages and doing everything they need to do to close those leakages?
Absolutely. I think that, the responsibility needs to be shared with the provinces, but there needs to be, like I mentioned earlier, a mandate, because if there's no mandate, we'll get the same response in a year or in 10 years from now with the next generation of bureaucrats. This is a clear and present danger now. It was mostly on the West Coast for the past 30 years, but now on the East Coast, with the example of Royal Greenland in particular, which is flagrant. This is completely unacceptable here in Canada to have this going on, but it's let go. And it's like if the sky is blue and the sun is shining over us right now when you talk to these bureaucrats.
Do you see it as government's role and responsibility to protect coastal communities, to ensure that they do everything they can to make sure that profits stay in our communities? When you hear $52 million in profit, Royal Greenland, that money is coming out of the hands of fishers. Do you not see that and agree with that?
Absolutely. Mr. Malley? At the end of the day, if we want to have small coastal communities that are vibrant and surviving in the future, we need to have these fishing industries thriving in these areas, and the benefits of the resource go back in these areas to the benefits of the coastal provinces also that need this fishery. At the end of the day, that has to be done with collaborations with the provinces. And again, I think that a proper study should be done. It may take a little bit of time, but it needs to be done now before it's too late.
I guess my question is the government making this a priority? Mr. Sproul, you've heard about obviously sharing risks and benefits on the West Coast. Simple request to government, public registry of who owns foreign ownership, of quota. And we can't even get that. It's been 2 years. All we keep hearing from the government is they're taking a look at it. Do you think the government's really serious about taking this on?
I think it's important to recognize that companies like Premium Seafoods are at the core of the destruction of coastal communities in British Columbia, and the conglomeration of fishery access into the hands of a few corporations has really, really damaged coastal communities. And the government certainly has a duty to not follow down that path in Atlantic Canada. But I think there's a bigger question, Mr. Johns, and it's that this deal is not economically, socially, or environmentally just. And the comments previously that inshore fishermen are not capable to access these grounds belie the truth that there is an amassed fishing fleet on the line that divides the inshore from Clearwater's offshore monopoly. And those fishermen can see Clearwater's offshore lobster fishing vessel from that point. There is the potential here for moderate livelihood integration on this deal, and it needs to be examined.
Okay. Ms. Kinnett, how much time do I have, Mr. Chair?
30 seconds.
Ms. Kinnett, you talked about, an approach the government might be able to take to look at the socioeconomic opportunities and leakages. Can you share just a little bit of a perspective on how government could improve in terms of plugging these leakages?
In 30 seconds, I may need to give you a written answer to be thorough and precise. How it could plug it? If I may, Mr. Jones and Mr. President, I would like to respond in writing to that question to be appropriate.
I'm sure that'd be appreciated by the committee members as well. We'll now go to Mr. Mazier for 5 minutes or less, please.
Thank you, Chair, and thank you to the witnesses today for coming out. This is really good testimony. Mr. Sproul, At the previous committee meeting on this study, we heard from a vice president at Clearwater who stated that the topic of moderate livelihood fishing is entirely separate from the Clearwater transaction. In your view, is there any potential impact of the Clearwater transaction on the issue of moderate livelihood fishing?
Most certainly there is. What I saw when my members heard that there was the potential for the sale of Clearwater fishery access, we were elated because we assumed that the government would buy that access and convert it to moderate livelihood fishery access. I think that, you know, at the height of a fishery crisis in Atlantic Canada, this tremendous opportunity presented itself, and the government turned its eye on that and turned a completely blind eye to it. The truth is that there's a tremendous economic potential in Clearwater's offshore lobster monopoly, and opening adjacent LFAs to that area would reduce fishing pressure in the inshore and open a tremendous area for moderate livelihood fishing, whilst at the same time building acceptance among the commercial fishing industry for integration of Indigenous people. It would be a win-win for all communities in Nova Scotia. Maybe not a win-win for politicians involved in this deal, but I think it's important to point out that it can still happen that way, and that it would be mutually beneficial to Indigenous and non-Indigenous fishermen. The lobster access was granted to sword fishermen in the 70s because of the mercury crisis, and was broke up into many different licenses. And since then, because of manipulation of policy and lobbying, they've been conglomerated onto one vessel that, to my knowledge, has no Indigenous fishermen aboard of it. That one profit-driven enterprise would replace the potential for hundreds of jobs in the moderate livelihood fishery. I find it beyond belief that Minister Jordan would ignore that potential.
Wow. Gee, thank you for that. Mr. Sproul again. I know that the United Fisheries Conservation Alliance has written to the Minister on multiple occasions to raise concerns relating to the future of Canadian fisheries. Do you feel that the Minister is listening to the views of the UFCA and to the fishermen that your organization represents?
I would say absolutely not. That's my view, and it's the view of my members. And as proof, I would point out that the Minister appeared before the Senate Standing Committee last night and said that very thing. She was quite proud of the fact that she'd had zero consultation on the deal with the commercial fishing industry. And as I said in my earlier statement, when communities adjacent to resources lack a voice in regulatory regimes around them, they invariably lose, be they Indigenous or non-Indigenous. And I think it's important to point out that what's best for Indigenous leaders may not be best for Indigenous fishermen. I'm concerned with outcomes for fishermen on the water.
Okay, thank you. And this is for anybody. I guess we can start for the others. Can you expand on the effect what we could expect in principle if the principle of owner-operator is weakened and not enforced? So we'll start with the other and go from there, because Mr. Collin, you've spoken enough already. Who's the other witnesses there?
Maybe I can give a few comments on that. And I think we have an example on the West Coast where, I mean, they have not set up the same protections as we've had on the East Coast to protect the owner-operator concept and principles. And today, their fishery is mostly owned by corporate entities and owners of the resource or licenses and quotas that don't operate the vessels. And you get less benefit at the end of the day when for the communities and the survival of these communities all along our coasts, when the benefits of these resources are concentrated into a few hands and pockets instead of spreading it out to captains and crews.
Ms. Kane, do you have any comment?
I think that, yeah, one of the core of the issues in relation to the protection of owner-operator is that we are protecting a diversity of enterprises, independent enterprises. When we don't protect that, and that fabric, that socioeconomic fabric, and that we go into corporization in the hands of one or two or three big groups, automatically we do see another economical logic going into it, and which is not new. We had the Robins in Quebec for 100 years and other companies, and today we are facing the same situation where if the fabric of multiple small independent enterprises fishing our waters is not protected, then we go into a logic of 2 or 3 big companies with other economical interests. And the clear example, and goes quickly, and the clear example is what happened, unfortunately, in British Columbia.
Thank you. We'll now go to Mr. Morrissey to finish off for 5 minutes or less, please.
Thank you, Chair. And I have one question. I'll split my time with my colleague, Mr. Cormier. I want to compliment the 3 witnesses. I was very impressed with the testimony you gave. You articulated very well the condition or the situation facing the East Coast fishery. We all know who loses fishers in the long term at the shore price when you got corporate consolidation. In the buying area, they have to recover their investments. They recover through reducing the price to fishers for the raw resource. That is a tried and true corporate philosophy and policy, and it's not going to be any different in this case. So we have to be vigilant. So I just want one question before I turn it over. So the issue that we as a government have to be vigilant on and ensuring that our First Nations communities who fought so long to get access to the fishery through communal fishing licenses, that those communal licenses must remain within the ownership control of the First Nations communities who have them. Am I correct, Martin? And Mr. Sproul and Ms. Kennett?
I think you mentioned 2 very important words there, Mr. Morrissey. The ownership and control is the second word is the most important. And this is another area of concern right now where, I mean, through the new Fisheries Act and the protections for owner-operators that came with that, there really needs to be a look at what is protecting First Nations from the same corporatization and international interests coming in and controlling First Nations assets down the road. And I mean, I would strongly suggest that these conversations also, I mean, happen with Indigenous communities to see if they have any options or ideas concerning this situation, which eventually will happen.
I think ownership of resources is what this all boils down to, and that the deal clearly creates a path for the removal of ownership from Indigenous people in the future. If the government cares about economic outcomes and about social outcomes for Indigenous fishers in Atlantic Canada, they would develop a way to deliver this access to individual fishermen on the water for their benefit.
Mr. Cormier will continue, Mr. Chair.
Thank you, Mr. Morrissey. Not because you're my favorite, but Mr. Mallet, just because you're from my province. You said it earlier, licenses are high price right now. Crab, we're hearing rumor 12, 15 million, lobster 1.5. When I see license leaving my province and leaving my area, it's troubling to me. Is there anything we can do to stop that? Because like I know the residence criteria are like all different within like different province. Like, what do you think we should do to stop that? Because like the nouvelle loi sur les pêches était pour faire en sorte d'avoir une séparation.
The Fisheries Act was supposed to have a difference between the operators and the fishers. We wanted to have the licenses in our community, not just for the benefit of our fishers, but for the communities. What do you think that we should do to stop the selling of the licenses to other provinces and to foreign interests? Well, it's not easy to answer that question, Mr. Cormier. We've been wondering ourselves what we can do to encourage the fishers, the families, and members of the community. We've been working on programs in cooperation with DFO to support the newcomers to the fishing industry. But also there's a question of financial investments from outside the province. We don't know quite where the money comes from necessarily. And it doesn't seem to have much to do with the real value of the business. There are some funds that come from outside. It's obviously from somebody who's interested in controlling the industry. So we're trying to look at the entire industry in more detail, not just the question of foreign ownership, but also to see what can be done to make sure that the assets that are currently held in smaller communities remain there. Do you think there's something lacking in the Fisheries Act that would deal with these foreign owners or people from outside the province who come in and take over? Well, obviously the provinces have a certain responsibility to have a structure in place to protect the assets. The provinces also have to come up with some assets and some systems to be able to look at the situation and also come up with their own solutions. Well, thank you very much. I think that my time is up. Perhaps Ms. Canet, you might want to add to that. There are just a few seconds left. Well, very quickly. One of the aspects that could be added to the Act would be the economic aspects of the fishery. And so this would be related to the fishermen themselves and the license holders. Obviously, since DFO doesn't have anything to do with that, we should nonetheless have the economic issues included in the legislation. Thank you very much. No, that answers all my questions. I'd like to thank you for joining us this evening. Thank you. And I know that the chairman wants to take the floor now.
Mr. Cormier, it's only a few seconds over and the 5 minutes. That absorbs our full little over 2 hours for this evening for our committee meeting. I want to say a big thank you, of course, to our witnesses this evening, Madame Canet, Mr. Mele, and Mr. Sproul. Again, a very informative meeting once again of our committee and the knowledge that you've shared with us this evening. I want to say thank you to the committee members, to clerk, analysts, translation, and the interpreters and everyone involved to make this meeting go off as smoothly as it did this evening. And I'll bid everyone good night and call the meeting adjourned.
Merci. Au revoir.